came here with full knowledge that 3 of the respondents hadn't been served with the application. Certainly our lawyers hadn't served them. And that they hadn't responded, and indeed they haven't. So my Lord, we hoped that court would listen to our crisis. And though, my Lord, you mentioned that what had been filed as an application 248 hadn't been yet drawn to the knowledge of the court. But information was passed on in this court about its presence and its purpose. On that day, my Lord, you chose to start with our bail application, which are the reason we are here today. The application of our co-accused Ola is of last year. It's filed last year. And we have during all these intervening periods in reminding the court about the presence of these applications and the need to dispose of them. So when we come here on the 30th, another pleasant surprise maybe, that now you want to fix them. But you want to fix them, so we are here on the 30th, you say the following day, on the 1st, prosecution should file their arrest books. On the 2nd, we find a rejoining, and today we hear the application and determine. We are very anxious to get out of prison. We have been there for nearly 20 months. Sadly, my Lord, it is when we have a crisis, deep crisis in our representation, that the opportunity to hear the bail application now springs up. So, my Lord, we actually don't know whether they responded, because we are now totally disabled. If they did, maybe they will have to serve us Brazil. How we respond, how the process is managed. Another open challenge. So, my Lord, we are faced with a situation, gross violations of the law with impunity, throughout this process. The illegal kidnap and rendition, the illegal general court-martial, the committal without lawyers, and what has transpired in the process of our presence here at the High Court. The latest crisis is caused by a respondent over whom we are complaining. It is the same respondent who deported Martha Karu, senior counsel. And unless we find a solution, the crisis of representation, it's very difficult to see how we shall proceed. We believe that maybe the intention of this terror on our legal team is to make it impossible for us to have lawyers of our choice, so that then the state can be our lawyers, give us lawyers. So, my Lord, our sense is that the rule of law, as we know it, is totally under attack, certainly in respect of what we are going through. basis of our application for it, which is still to be disposed of. As I pointed out at our last seat, I wrote down finishing. It's not possible to defend yourself when your hands and feet are tied, when your eyes are covered, and your lips are sealed. As is happening in our situation. This is not a matter that we face just as ourselves, but we believe it's a matter that the whole country needs to deal with. The question of the rule of law is an urgent matter which can face anybody, including you, my Lord. So, my Lord, when we are very anxious to get bail, I'm afraid to say that in the prevailing circumstances, we have indeed sympathized with our counsel. Let them off. We are extremely determined to insist on our right of representation by lawyers of our choice. And until that is possible, or until court directs otherwise, I think it's only prudent for us to remain in our prison until further notice. Of course, court can choose to go on in any situation, but in that event, we will only be in this court now, not just metaphorically, but physically, in handcuffs and cuffs on our legs. We cannot continue the process. Where fair trial, fair hearing is not taken.
I know whether the
My Lord, no addition, no subtraction.
Let me get the reply.
Let's please vote. Richard Billy from Bukachi, secretary for record. For institution stroke respondent. We'll give a brief reply to what the applicant has said. We'll give a brief reply to what the applicant or A1 has presented from the start to the end. We'll be very brief. Thanks so much. My Lord, as a prosecution or as office of the Director of Public Institutions, we took over this matter by way of fresh investigations if I recall well, between 11th and 12th of February of 2025. 11th and 12th of February of 2025. And we charged the three applicants, so accused persons, before Nakawa Court Chief Magistrate on the 21st of February 2025. And my Lord, it is common knowledge that the office of the DPP is not privy to what happens to General Court Martial, because General Court Martial falls under military justice system, and the office of the Director of Public Prosecutions under Article 120 of the Constitution is in charge of civil justice system. In that, my Lord, as office of the DPP, we are not aware that the accused person stroke applicant was arrested from Nairobi, because we are not privy to military justice system. My Lord, after charging the applicants to these persons on the 21st of February 2025, we committed them on the 29th of May 2025. And my Lord, it is not true that the applicant was committed without legal representation. His counsel appeared on that date and on record of the Chief Magistrate of Nakao. They just decided to walk away in protest. An act that would not in any way, my Lord, affect the procedure of committal of the accused person to the High Court. Because the substantive justice before Chief Magistrates Courts in capital matters such as this one is either commit or release the accused person if you not to proceed. And by that time, my Lord, the investigations were over. Now the office of the Director of Public Prosecutions was to simply exercise its mandate under Section 168 of the Magistrates Court Act. After committal, my Lord, prosecution was ready to have the accused persons or applicants tried. However, as rightly put by the applicant, the one senior citizen, Dr. retired Kizza Besigye, they bombarded this honorable court with several applications. Some of which made the hearing of this case at that time practically impossible. So we've actually wasted about 6 months in applications, my Lord. This is not to say that the applicants or the accused person do not have the right to make those applications. We appreciate that it was all within his right. But our argument is that those several applications affected the fair trial, I mean the quickest or quick trial of this matter. My Lord, we started disclosing in this matter right from January. And my Lord, what was remaining were basically about 5 statements. For witnesses whom we thought were at risk of intimidation, harassment, and compromise, among others. It is on that basis that we filed an application, sorry my Lord, an application for protection my Lord, that the deponent in that application, the land Chief State Attorney Joseph Chomhengo, was cross-examined for 2 days, if not 3, almost. Because prosecution, my Lord, was interested in a quick and speedy trial, not disputing fair trial, we decided to withdraw that application. Much as protection of witnesses is part of the fair trial. So we compromised protection of our witnesses for the sake of having this matter heard. After withdrawing our application, we fully disclosed the remaining 5 witnesses. The statements for those remaining 5 witnesses to defense. And we intimated to them, or to this court, my lord, that we are ready to have the matter to start. Defense brought another issue that we had to agree to some issues or facts which prosecution never had. And they were raising them, but they were not specific with those issues. And because of that, my lord, this court made an order that prosecution brings or presents its witnesses. We brought our witnesses, my lord. We brought 2 of them that time. Although for their statutory reasons they were not in this honorable court, but some were very close to the reach of this court. The applicants struck their accused persons filed an application for human rights enforcement. Against General Mhoz Kainerugaba and 3 others. My lord, on the 11th of June, this court gave out schedules. Gave directives on schedules in that application. And my lord, the main case was adjourned to the same date of the hearing of that application, on the 30th of June, 2026. My lord, on the 30th of June, 2026, court fixed the bail applications for A1 and A2. That is license application number 213 of 2026, and also license application number 0698 of 2025 for A3. My lord, the reason why these applications were fixed is because counsel for the applicants stroke accused persons had requested court previously to have the same disposed of. So the demand was to dispose of the said bed applications, the human rights enforcement application, and then they also asked for facilities to be available both at court and in the prison. That is the reason why, my Lord, the two bed applications were fixed. And also, in order to address the issue of facilities, this court, the accused persons wrote to court, and court wrote to prisoners. But I'll come to that later, my Lord. Let me first finish up with the issue of the bed application. My Lord, on the 30th, court issued directives that the respondent files their reply by 1st of July 2026, and the applicants make their rejoinder on the 2nd day of July 2026, if any. And then it was fixed today for hearing at 2 p.m. My Lord, just to remind this court and the accused persons is that on the 30th day of June 2026, counsel for the applicant stroke accused persons, led by counsel Tugumi, informed the court that they were ready to receive the directive or directives or schedules. And that's why this application was fixed today, or the two applications were fixed today. My Lord, this application, that is 213, okay, was not solely filed by Senior Counsel Martha Karua, Senior Counsel Kwago. I think it was filed by so many. It was a joint application, if I'm to remember very well. Okay, Counsel Kwago, the firm for Senior Counsel Kwago was part, but there were other firms which worked very hard to file this application. Council to Gumi on the 30th of June 2026. Maybe let me just make it clear that neither counsel for the applicant nor the applicant expressly informed this court that this matter wouldn't take off today. We appreciate that the issue of representation came up, but they were not to the point that this application would not take off. And as a result, my Lord, the respondent complied with the directives. We filed our response by 1st of July 2026. My Lord, as it has been a culture between counsel for the applicants and as counsel for the respondent, we have been having a cordial relationship in terms of service. Much as ECMIS, when you file on ECMIS, the other party is deemed to have been served. We have been having that cordial relationship that we normally serve the hard copy of our pleadings. So it is because of that relationship that we thought we could serve counsel in this matter. To our surprise, they said they cannot receive our service because they had no instructions. We were surprised, my Lord, because we hadn't seen anything on record for withdrawal of instructions. And that was the basis of the respondent serving the applicant's counsel. So, my Lord, as we came to the respondent is ready to have this application prosecuted. And my Lord, in matters such as this one, it is normally the applicant who should be interested in having the application prosecuted. My Lord, before I go to the tail end of this application, I just wish to say a few things The applicant raised the issue of Council LUKWAGO being arrested. My Lord, we are aware that he was charged with misprision of treason. However, we are not aware that he was arrested by General Muhoozi. We are not aware, my Lord. And we are also, my Lord, not aware that Senior Counsel Martha Karua, whom we respect here, was deported and declared persona non grata by General Muhoozi. My Lord, we have always respected the representation of the applicants, stroke accused persons, and we shall respect that because it forms part of his constitutional rights. My Lord, the applicant submitted that he sympathized with his legal team and as such relieved them of their duties. I hope I got him very well on that. And he said that until the recent application concerning his representation is addressed, nothing actually happened, and is willing to stay in prison. My Lord, it is a submission as respondents that since the applicant is anxious to leave prison, then you should have allowed to have this application prosecuted. And my Lord, we are inclined to submit that this court has powers under Section 37 of the Education Act to give any remedies to a party before it. And my lord, our remit is under Section 72(2)(a) of the Education Act. I mean 17(2). Section 17(2). Section 17(2)(a) of the Education Act, Cap 16. To have, my lord, this application dismissed. This application, my lord, can always come up because as respondents, we are not aware of the application in respect to his legal representation. So it would be hypothetical and speculative on our part, my lord, to start scrutinizing the merits of that application at this level. So this dismissal, my lord, is intended to curtail any delay in trials. Which emanate from abuse of the legal process. This is not to say that the applicants, that as respondents, we don't believe in the applicants right to apply for it. We believe in that. And that's why, my lord, we work tooth and nail to ensure that we file our response by 1st of July 2026. Under pressure by the reason was to ensure that we propel Article 28 of the speedy trial, my lord. My lord, in this court, speedy trial. So, my lord, we so submit. Of a letter from prisons yes, we got a letter from the registrar attaching a response from Uganda prisons dated 29th of June 2026. My lord, this letter is to the effect that the prisons authority have granted granted, and you are going to provide facilities to the applicants, stroke accused persons, which they initially prayed for. Although my lord, we are not privy to the letter which he talked about, which Colonel retired Dr. Kizza Besigye talked about that he filed, whereas the respondents are not privy to it, so we do not know the details of the said letter. Nonetheless, we reiterate our earlier submissions.
His understanding of what cognitive process should be in respect of the accused, I believe is not in line with the law. I think in a trial, the seriousness that has been so much talked about by the prosecution itself, the defense is entitled, has a right to be represented at all stages, and especially Community is a serious stage. It was our right to represent. Regarding disclosures, again the point was made here in court. That the reason we talk about full disclosure is that you can only know the whole case once you have all the information, not parts of the information. We were only able to know whether we have all the information on June the 1st. Though the disclosure began in January, it continued piecemeal all the way. But more critically, the main thrust, the essential element of the disclosures is in electronic documents. Videos and audios. this day, as we stand in court, we have never received them, viewed them or heard them. Because the order for facilities to do so was given in this court on that first day of June. The registrar, the deputy registrar, whatever the case, was supposed to communicate those instructions to the prison authorities. To the best of my knowledge, the instruction about facilities being accessed in the prisons to view these things has never been communicated by the deputy registrar to the prison. Unless, of course, the OC misinformed us. What the deputy registrar wrote, the letter was read to us, was for provision of time in weekends and public holidays, accessing the prison in the weekends and public holidays, period. And when our lawyers heard what was communicated to the prisons, they came back to the deputy registrar to inform about the problem that still existed. Since there is a letter in court with the Constitution, maybe they can help courts to read to us that facilities have been allowed in the prisons. It would be news, not a news to me.
Kindly, it's okay. Can you read that letter? Can you read that letter? Quote.
Letters,
No, the one from Zira.
prison.
Read.
is dated 29th of June, 2026.
29th?
29th of June, 2026.
Already.
My Lord, it is addressed to a Deputy Registrar of Criminal Division, Kampala. I go ahead, my Lord. And it is in response to the requests presented by lawyers for criminal session case number 335 of 2025, Uganda versus Retired Dr. Kizza Besigye and others. 1. Reference is made to Kampala High Court Criminal Division Deputy Registrar's letter dated 18th of June, 2026. Reference, guidance on requests made by lawyers in criminal session number 335 of 2025, Uganda versus Retired Dr. Kizza Besigye and others. 2. Below is the response to the respective requests. The lawyers of the accused persons be provided with unrestricted access to the prison facility from 8 a.m. to 6 p.m. to ensure preparatory meeting time as required for purposes of taking a full account of the events and identifying potential witnesses for accused persons and attending the facility with such people from time to time. Response. Access granted from 8 a.m. to 5 p.m. B. Lawyers and the accused persons be provided with an interview room free of any officers of the state and which is large enough to accommodate 15 to 20 lawyers and any assistants to ensure that the advocate, client privilege, and necessary confidentiality is accorded. Response. The spacious room large enough to accommodate 15 to 20 lawyers and any assistance is available and will be provided. Second response. The client advocate privilege of confidentiality will be accorded with the prison officer being in sight but not in the meeting of the ongoing interaction as provided for under section 63.3 of the Prisons Act, Cap 325, regulation 54.3 of the Prisons Regulations 2012, and chapter 38, paragraph 8, subparagraph 5C of the Prisons Standing Orders, part 2, 2017. C. Lawyers of the accused persons be permitted to bring in and take out of the facility on each day of consultation. A. Projector and whiteboard stroke background. Response. This will be provided. 2. Laptops, mobile phones, ear stroke, headphones, and mini sound speakers. Response. Laptop, ear stroke, headphones, and mini sound speakers will be provided. B. The mobile phones are not granted entry into the prison, but can be kept at the outside visitor handling office where the lawyers can access them with ease. Mobile phones are key prohibited items in prison as per chapter 45, paragraph 2H of the Prison Standing Orders 2017. 3. Internet connection which is secure to facilitate on-spot research. Response. This is not granted in the lawyer's interaction room, but we shall avail an alternative nearby room equipped with internet accessible to only lawyers for research on need basis. D. An IT expert of the accused person's choice to assist in defense preparations be allowed to prisons with lawyers of the accused persons. Response. This is hereby granted, but upon full identification. E. A forensic examiner of the accused person's choice to assist in defense preparations be allowed access with the lawyers of the accused persons. Response. This is hereby granted, but upon full identification. Lawyers of the accused persons be allowed access to the facility with all case files, flash drives, notebooks, pens, statute books in hard and soft copy as may be deemed necessary for effective consultations. Response. Grant of access is hereby accorded to all case files, notebooks, statute books, big crypto ballpoint, pens, and flash drives containing only electronic evidence and soft copies of statutory books. G. Permission to access the facility with the necessary meals and refreshments for those attending the consultation sessions. Response. The refreshment that is packaged water is hereby granted for the lawyers. The accused person's refreshment will be got from their internal stock. While for food, the lawyers are at will to have scheduled meal breaks, as the accused persons also go back to their residence for their internally prepared meals. H. Lawyers representing the accused persons will be granted access with the required confidentiality to the accused person at court before commencement of every court session. Response. The interaction with the accused person, with the accused before court commencement is granted, but subject to statutory assessment and controls. Most obliged. Meet on TO for Commissioner General Prison, CCBI.
Yeah, so, as you heard, that letter is of 4 days ago. Certainly our lawyers haven't seen it, I'm sure, because it came during the crisis we are talking about. And nonetheless, there is some progress that is registered in the letter. If and as we are able to reassemble a legal team, hopefully that letter will be made available to us. Is it copied to any of our people?
Yes, it was copied, my lord, to the first council.
Yes.
And yes, and state attorneys. Yes, my lord.
On the surface, I could hear contentious areas, but I guess those will be dealt with once, or if we resolve the question of representation. Beyond, the DPP continuously refers to speed the trial, speed trial. It says they withdrew the tom handle. Application for witness protection. Facilitate that big trial. And expose their witness to risk which they were trying to protect them. So, Mr. Judge, you can imagine the we are seeking to protect army officers, senior army officers, and they are now worried about their security. Where does that leave our lawyers, who are directly threatened by the senior-most military officer in the country? Military officers themselves needed protection. Can you imagine what we are faced with? Those who need protection against general wars. On preliminary hearing, agreed facts is only one element of the preliminary hearing. All these others are part of that preliminary hearing. And agreed facts, if they are none, it's just recorded that they are none. But it's a legal requirement that if they are agreed facts, agreed documents, then a memorandum is worked out and signed by all parties. But to conclude preliminary hearings, when these other matters had not been dealt with, including this application, including the access to the disclosures, because preliminary hearing and the trial was supposed to begin on 11th June. This letter, which is now giving access, is of 29th of June. And there rests our concern. That we are expected to come here on 11th and face a witness before we access the disclosures. I'm surprised, my Lord, that the DPP comments in the matters of our application for human rights, where he is not a party. When the Attorney General introduced prostitution, when he was introducing his team, we thought it was a slip of the tongue. Now, prosecution is telling us what happened on the 30th in respect if we were really interested, as we are, in getting freedom, liberty, our submission to you, my Lord, is that even the bail application cannot be meaningfully processed in the current circumstances that are not of our own making. Even our sureties are under threat. The Honorable Semujunganda, who is one of the sureties we presented in this matter, has been told he's the next one after LUKWAGO by the same general. I haven't seen him since. I don't know whether he's in hiding. If Council Togune and the few lawyers who were here on the 30th created the impression that they were a team instructed to continue prosecuting these matters, I think it would be a wrong impression. We met the lawyers before we came here in the court cells down here. And our clear understanding was that they were coming to raise the alarm about their situation. To indicate how the team has been decapitated and rendered unfunctional. If you were decapitated, Mr. Richard Devo, God forbid nobody does. But if you are decapitated, you can't refer to the body as still able to continue doing something when it has lost its head. Simply can't happen. Because the body functions as one. Some parts are not as critical as others. You may lose a finger, you may even lose a hand to continue function. But when you are decapitated, when the head is removed, you have to rebuild afresh. So, if an impression was created that by their presence, and they talked very clear and loudly in court in my presence and hearing, and all of us here, about their dilemma. I think one said that he was even not sure whether he will get home here. Has come so by, I think, right now. So, team is simply whether there is one or two or three, they function as a body. It was rendered dysfunctional. Our attempt now is how to deal with it. Defense counsel definitely told you the truth, but there was no instruction to receive the response on mail. We don't have witness ourselves. We don't even have access to it, even if we had computers. If they have not communicated, I guess failure to communicate cannot be visited on us. I'm inclined to agree that prosecution does not know that General Muhoozi Kaimerugawa is behind, was responsible for the arrest of Council LUKWAGO and for the deportation of Martha. I'm inclined to believe that. And that is why we filed that application 248, so that evidence is adduced, show that he is responsible. The respondent is responsible for the terror, which we need to deal with. Regarding the recommendations to dismiss this bail application, I think we've been very clear that we are very keen on bail. Indeed, if these applications had been heard in accordance with the bail disposal regulations that are in place today, this crisis would never have arisen. Bail disposal regulations which are in the Constitution, bail guidelines for courts of judicature, practice, directions of documentation. They provide that bail applications should be disposed of within 30 days. If our bail application had been heard and disposed of within those 30 days since we filed it, we will not be here today. As I pointed out in the case of my co-accused, Tenola, his application is of last year. simply incapacitated to act because of the reasons I have presented to court, that we have challenges of legal representation and therefore of communication. We didn't receive your reply. We can't rejoin the reply. We are simply stranded. I've also indicated that even our witnesses, at least one of them, have been informed, is under threat. One of the sureties, Honorable Senator. So, my Lord, I leave it to the court. Dispose of it with all those concerns registered. That's it.
Now, Samira testified. I will deliver this ruling next week, so 8th, and I'll deliver it on 8th, and I am ordering that the hard copy will be delivered to you in Muzira through Muzira offices. You get it in Muzira that day by 3.
Still appear together, my land friend, which are LUKWAGO State Attorney, and George Bigira, Senior State Attorney. My Lord, we came ready to proceed with this bail application here.
You may hear from the applicants while the material is the record.
Before I address the reason as to why the lawyers are not present, I want to reiterate some of the concerns that was raised by A1, and that to be specific in regards to the facilities to enable us access the requirement. I'm happy that there is a letter of date 29th of June, just trying to address that simply. But before that, all of us were faced with the same dilemma. So back on the bail, I would like to bring to the attention of this court that today as I speak, I'm actually making almost 3 years in detention. And really it is in my interest that this bail had to be disposed of. The bail is of 2025. And as I may recall, it was first fixed for hearing on, it was supposed to take place on 27th of January 2026. But before that hearing would take place on 25th of January, a production warrant was produced. Reason? Rescheduling that the hearing will happen on 26th of February 2026. On 25th of February, a letter from the deputy registrar again went to the prison, which I received actually on 26th in the morning, cancelling the said hearing, promising that the next date will be fixed as soon as possible. My Lord, I'm bringing this narrative so that the court get to understand that for the past 3 years, I've been incapacitated, I'm not working, therefore not earning anything. Each and every time that court schedule a hearing, I have to transport the sureties all the way from Gulu to come and attend. And for those 2 occasions, the cancellation comes when they have already traveled. Yet this money I have to source from relatives, friends. Also putting into consideration that communication itself in prison is not at our disposal all the time. So the last time we were here, on Tuesday, you gave us directives and you fixed the date for hearing for today. We went back to prison